I just wanted to bring to your attention a recent case on testamentary capacity decided by the Chief Justice of South Australia. The case is ROCHE and ROCHE, and it contains a lot of interesting information. First, there's an excellent review of the authorities, legal authorities, on what is testamentary capacity. But the Chief Justice makes this quite interesting and I think perceptive remarks about testamentary capacity in accordance with the Banks and Goodfellow test that we're all so familiar with. He says this at page 5 of the judgment. As with other 19th century common law principles governing the legal effect of mental illness, the statements in Banks and Goodfellow no longer reflect modern medical knowledge. It is now recognised that there is a broad range of cognitive, emotional and mental dysfunctions, the effect of which are difficult to identify precisely or delineate from the exercise of one's natural faculties and the reasoning capability of the sound mind. Moreover, the rules as to testamentary capacity must recognise and allow for the natural decline in cognitive functioning and mental state which often attend old age. I thought that was the first of those sorts of remarks that I've read in recent times. The other two aspects that I thought were interesting, it goes for 147 pages, and the Chief Justice very exhaustively looks at all of the evidence because the gentleman concerned was diagnosed and clearly suffering from what was called frontotemporal dementia, and in the end he called a concurrent testimony of geriatricians, had 3 medical specialists present, and he said in his judgment, I asked all 3 witnesses concurrently in a conference room setting a series of questions and asked them to comment on the answers. Additionally, thereafter, the counsel for the parties were then asked the geriatricians questions again regarding their views and gave the opportunity to comment on the answers of others. So it was a big estate that was no doubt at risk, and the care taken by the Chief Justice in that approach I thought was quite interesting, and I wouldn't say novel, but interesting in the context of this testamentary capacity issue. The problem being that the particular dementia that the gentleman was suffering from, the judge, obviously Chief Justice, needed to know to what degree it was affecting his ability to have testamentary capacity. In the event, he said that he did have capacity, but a very, very thorough analysis of a whole lot of conflicting evidence was necessary for the judge, Chief Justice, to reach that opinion. The only other comment I'd make is that the opinion of one of the medicos who gave an opinion was commented upon very adversely by the Chief Justice. In fact, he said things like that this doctor's evidence was completely unsatisfactory, and he also said, I have no confidence in this doctor's evidence or the opinion expressed in his report. I guess when I read that, it made me realise that when we do call for expert opinion from a medico, for example, that it's important to perhaps check to see whether the person concerned has given evidence in the past and whether in fact that evidence has been accepted or not. Just a practical aspect that I thought was worth commenting upon. Anyway, it's a very long report. I think it impresses because of the thoroughness of the analysis of an enormous wealth of evidence that was provided, but I thought those few points that I raised were particularly significant. I hope you will get some benefit from the case as well. Thank you.